of the 10 judges and jurists from the United States is part of an effort to fulfill at least 5 major objectives. First, the objective of coming together as democracies and to recognize the role of democracies in advancing the cause of the rule of law. Second, to be able to recognize that democracies cannot take the rule of law for granted. Even though constitutional democracies with their own independent institutions are better placed to position and protect the rule of law, they also face challenges. India and US are no exception, and the effort is also to recognize those challenges and to prepare ourselves to better respond to those challenges. The third effort is to introduce the Indian judiciary, the Indian democracy, the Indian democratic institutions to these individuals who have themselves vast experiences in their own life. Many of them, in fact, the majority of the visitors are visiting India for the first time, and they have been quite struck by the extraordinary diversity and the complexity of our democracy. The fourth objective of this visit is to give them a perspective about the diversity of the country, both in terms of its language, its culture, its traditions, but also its geography, its diversity in terms of its institutions, but also how it is governed despite all its diversity. And that is why the visit has been organized across 5 different states and cities of India, starting from Delhi, and then to Mumbai, and then Chennai, and then Bengaluru, and ultimately ending in Kochi in the state of Kerala. The next objective is also to build partnerships and collaborations with institutions. One of the things that we are also looking at is that how can we build this effort to the next level where this becomes an annual event, an exercise for both our judiciaries and our institutions to be able to work together. Because at the heart of this effort is that we are indeed confronting some of the big challenges of our time. As some of the judges will tell you more, issues relating to freedom of speech and expression, issues relating to speaking truth to power, issues relating to the very idea of pluralism and democracy, the issues relating to equality and non-discrimination, the issues relating to environment and climate change. These are not issues which countries can respond to in an isolated manner. They require collective imagination and conscious effort to collaborate, and that is also part of this effort. And the last reason why we decided as a university, as a law school to do this is that universities and law schools have a very big role to play in bringing together individuals and institutions. There is no institution in the entire gamut of any society other than an educational institution, other than a university, other than a law school, which can actually bring together complex individuals and institutions to be able to help them to think collectively and to respond to those challenges. I consider this as a responsibility of a university and a law school, and that is why O.P. Jindal Global University and Jindal Global Law School chose to bring together these amazing, outstanding judges and jurists to India and to be able to give them an opportunity to discover India through law and justice. At the end, I would like to extend my heartiest greetings and appreciate all of your presence here so early in the morning, especially the Honorable Minister, because I can understand these individuals who are engaged in public life, they work till very late and the demands of their time are so significant, and for him to take out time so early in the morning and to be present with us demonstrates how seriously committed he is to the vision and protection of the rule of law and to promote access to justice. Thank you very much to all of you and wish you the very best.
Thank you, sir, for your insightful introductory remarks. I now invite our next respected speaker, Honorable Justice Sri Swatantra Kumar, former Judge, Supreme Court of India, to enlighten us with an introduction to the Indian judiciary.
Good morning to all of you. Honorable Law Minister, the Surana family, on the stage and off the stage, and dear friend and hard taskmaster, Mr. Raj, the Vice Chancellor. respected members of the audience, the chairman of the Bar Council, and distinguished gathering of lawyers and special invitees. I have been with this foreign delegation at the behest of the great man on the dais. I would first tell you that the two things which I have noticed with these eminent honorable justices and judges and the dean from different parts of the United States is they are people of great patience. I think the way they have taken this tour of theirs with the intensity and sincerity about their learning and interacting with people is remarkable. And I really say thank you to all of you and welcome you to India. Well, another thing I was thinking when we entered the building today, so I got this pearl ring. So one thing is that all of us visiting them today, Surana family, have become richer by pearl ring. But besides that, this gives you the affection, the respect the institution has for you to come here. So please always keep this as a sign of their affection and respect to you rather than just a string of pearls. I have been assigned the job of telling you about the Indian judiciary. Well, to tell you about the Indian judiciary, maybe the tea time would come and still the Indian judiciary history wouldn't end. But realizing that the Honorable Minister will have a lot of limitation, I'll try to confine myself to the time awarded to me. Now in India, we have a four-structure judiciary. Whether it is criminal or civil, there are primarily two fundamental jurisdictions the court exercise. Like petty offences will be triable by the magistrates, which are the first courts under the criminal jurisprudence. The serious, heinous crimes will go to the session courts. Appeals will lie to the High Court. And finally, by allowing or permitting a certificate to be issued by the High Court under Article 134A, the appeal will lie to the Supreme Court of India. So a litigant normally has 3 chances of testing his luck as to whether he succeeds or he fails. Similarly, in civil, we have the same thing. That is the civil judge, then you have the district judge, then you have the High Court, and then you have the Supreme Court. We do not have a court of appeal or any structure between High Courts and the Honorable Supreme Court of India. That is the outer structure. What I really wish to place for your kind consideration is that the remedies that are available to the people. Now, the Supreme Court of India and the High Courts exercise which is called extraordinary original jurisdiction. That is the constitutional jurisdiction these both courts exercise under Article 226 of the Constitution and Article 32 of the Constitution. Now, this is a remedy which is the backbone of our legal system. Every citizen, in the event of there being actually a breach of fundamental rights or the likelihood of a breach of the fundamental rights, would have a right of writ directly in the Supreme Court under Article 32 or before the High Court, even which goes wider than mere fundamental rights. This jurisdiction is termed as the basic structure of our Constitution. And the Supreme Court has very vehemently stated that even Parliament cannot alter this basic structure of the Constitution, despite the fact, because in India, it is not the Parliament supremacy, It's the constitutional supremacy which prevails. The two things which have happened is now we can connect the legal system to its rule of law. Now, once we talk of rule of law, it is primarily concerned that what kind of remedies are available to an ordinary citizen and how inexpensive, expeditious, and access to justice can be provided to him would determine the rule of law. As Mr. Surana just said, that it is not only the running of an administration of justice system which will by and large conclude or define the rule of law in a country, but it will be the participation of the citizenry in administration of justice on the one hand, on performance of their natural and constitutional duties under the Constitution. You will be happy to know that under the Indian Constitution, environment has been given a very, very high pedestal, significant recognition. Here there is a constitutional duty on the government to protect the environment. There's a constitutional duty on the citizens to protect the environment. And then the Supreme Court says that Article 21 will give you the right to decent and clean environment. So this normally, which was termed in the judgment, was the golden triangle of environment in the Indian Constitution. Now, access to justice has two factors. That is the locus standi, and secondly, the procedure to access to justice. Now, the concept of public interest litigation in India became one of the major tools of administration of justice by the highest courts of the state and the country. Even a letter from a litigant was treated as a writ petition. So that will show you the extent to which the procedural law has been relaxed to ensure that your procedural impediments do not frustrate the rule of law or justice to the people. So one sitting in a remotest area